It is Thursday, March 27, 2025. The time is 5:35. First, very quickly, we will be re-referring Senate File 2856 to the Judiciary Committee. This was Senator Carlson's bill that we heard last Friday, but we didn't do the motion to refer. So Senator McQuaid moves that Senate File 2856 be recommended to pass and re-referred to the Judiciary Committee. All in favor say aye. Aye. All opposed say no. The motion prevails. Senate File 2856 is recommended to pass and re-referred to the Judiciary Committee. First up, Senator Klein. Senate File 1734. Whenever you're ready, you may proceed.
Thank you, Chair and Committee. It's good to be back in the State Government Committee. I'm shaking off the PTSD from my last visit. But thank you for hearing Senate File 1734. I have with me the august members of the Secretary of State's office today, but I'll tell you a little bit about the bill myself. The Minnesota Business Filing Fraud Prevention Act is an important step in protecting Minnesotans from business identity fraud. Bad actors can and have hijacked legitimate businesses or create fake businesses in someone else's name, and victims often don't realize what's happened until they're facing bills, legal trouble, or tax liabilities for a business they never owned or for actions their actual business did not take. Office of the Minnesota Secretary of State handles phone calls regularly from Minnesotans who are suddenly dealing with this crime without a clear answer of why and how to clear their name. And the office currently lacks the statutory ability to help beyond aiding law enforcement who may investigate. So Article 1 of this bill, Mr. Chair, creates a clear process for handling fraudulent filings, making it easier to literally set the record straight and unwind the damage. It's near impossible to pass laws at the speed that criminals can abuse systems, and having a direct path to challenge and remove wrongful filings ensures that victims can reclaim their businesses and identities without long delays and costly legal representation. Article 2 seeks to address another common issue the office receives calls about from business owners across the state, and that is solicitations, offering to complete operating requirements for a fee. So procedures that they say the Secretary of State's office requires for your business, when in fact those operations can be performed manually without any fees through the Secretary of State's website. So this can easily deceive business owners into paying for a service that they could do for free on the office's website, and I have a testifier.
All right, General Counsel, whenever you're ready, please state your name and you may proceed.
Wonderful. Good afternoon, Mr. Chair, members of the committee. My name is Lauren Bethke, and I'm the Deputy General Counsel for the Secretary of State. Thank you very much to Senator Klein for carrying the bill and to the committee for hearing the bill today. I'll start by going through the process in Article 1 at a high level, but happy to take questions afterwards or go into more detail. So yeah, right now our office doesn't have the authority to remove a fraudulent business filing unless someone goes to court and gets a court order. So this bill creates a process that allows us to do that after going through some steps to ensure due process. The first step is that a person would contact our office and make a declaration of wrongful filing. So they will explain, this is who I am, this is the filing that's at issue, here are the reasons that I believe it was filed wrongfully. Our staff will review the declaration and then give notice to the complainant, which is the person who filed the declaration, and the filer, who is the person who made the original filing. The notice will describe the complaint and explain the process and the timelines. Once the notice is given, the filer has 21 calendar days to respond. If they don't respond, we would presume that filing is fraudulent and issue an order. I'll talk a little bit later about what the next steps are in that case, but that's the first notice and opportunity to respond. If the filer does respond, we would look at their response and make a preliminary determination of whether the filing is fraudulent or not. And then we would give notice of that preliminary determination, and the non-prevailing party would have 10 days to respond. If they do not respond, the preliminary determination becomes final. If they do respond, we again consider any additional information and then make a final determination. If our staff ultimately does determine that a filing is fraudulent, we would issue a final order explaining the rationale for that decision. We would also mark the filing as fraudulent or unauthorized in the business filings database and redact any names or other personal information that was used without authorization. On the other hand, if our staff determines that a filing is not fraudulent or if there's not enough information to make that decision, we would issue a final order explaining that rationale, and then of course the filing would stay in place in the database. In either situation, the non-prevailing party could appeal that order in district court, so there is an option for judicial review of our office's determination. So that's the overall process for Article 1. Article 2 adds a section that addresses another problem we hear about, which is deceptive mailings. I won't go into that in detail, but happy to answer questions about it. And then Article 3 is conforming changes. So that is a very fast overview, but again, happy to take questions, and I have some other folks from the office as well.
Thank you, Deputy General Counsel. With that, members, any questions or comments to Senate File 1734? Senator McQuaid.
Thank you, Mr. Chair, and thank you, Senator Klein, for bringing the bill. Hopefully I can ease the experience a little more this time. I really appreciate you bringing this. I remember seeing a really in-depth piece or series that was done about I think some plumbers and this having happened to them. And so it's incredible the ways in which people will commit fraud, and and it's always hard to be chasing behind them, but to have the ability to alleviate some of the administrative burden for victims of fraud is incredible. So I just am really appreciative of you focusing on this, and as well as the Secretary of State's office. So thank you so much for bringing the bill.
Thank you, Senator McQuaid. Members, any other questions or comments to the author? Senator Klein, any final comments for us?
Appreciate the indulgence of the committee and the assistance of the Secretary of State's office. Proud to carry this as the Commerce and Consumer Protection Chair as a significant protection for Minnesotans with businesses in our state.
Thank you, Senator Klein. With that, Senate File 1492 is laid over for possible inclusion. Senate File 1734 is laid over for possible inclusion. Thank you, Senator Klein. Next up, Senate File 2322, the Minnesota Healthcare Workforce Bill, Senator Wiklund. Senator Wiklund, whenever you're ready, you may proceed.
Thank you.
Thank you, Mr. Chair. Senate File 2322 is a bill that would establish a healthcare workforce advisory council. It would be a council that uses data analysis and research that draws upon existing sources and entities to perform workforce planning in a collaborative and coordinated manner. We took learnings from other states that have already established councils, and we will provide recommendations to the legislature and other stakeholders regarding healthcare workforce needs, helping to draw out what our priority opportunities and needs are for investment, and how we can ensure better, more efficient distribution of our investments. The origin of this bill is from the U of M Academic Health Center Task Force that I was a part of in 2023 and 24. And one of the recommendations from the task force was to do a better, more coordinated job of looking at our workforce needs going forward, and how could the legislature have better insight into what we should be financing. We have several entities that work on healthcare workforce planning, but there's no collaboration or coordination of these different entities. And so that's what this workforce council would do. I do have a testifier who is online, and I do have an amendment. I worked with Ms. James this morning or today to do some work on the operational aspects of implementing the council. She helped with some of that, and then organizational, just organizing some of the language. So if you'd like to have the testifier present her testimony, and then I can go through the amendment, or the other way around, whichever you.
Certainly. Members, there should be a 8-3 amendment being handed out here to this bill. Maybe we'll have your testifier go, and then we can take a vote on the 8-3.
And Nitika Moibi is, I believe, online.
All right.
Yes, thank you, Senator.
Hello, ma'am. Welcome to the State and Local Government Committee. Please state your name for the record, and you may begin.
Thank you, Chair. Thank you, Senator Wiklund. Good evening, everyone. My name is Nitika Moibi. I'm with the State Health Department, Office of Rural Health and Primary Care. Thank you for the opportunity to share information about Senate File 2322. As Senator Wiklund mentioned, this was an assignment given to us by the legislature last session to think about developing a central workforce body to advise the legislature and to coordinate healthcare workforce planning and investments within the state of Minnesota. To plan this work, we had 2 representatives from the University of Minnesota. We had 1 representative from the Minnesota State Colleges and University, and one representative from the Health Department, including staff that helped staff this work, including myself. Some of the guiding principles or the key themes that came up and were part of the discussions were that the planners really acknowledged the need for a central body that had a comprehensive view of the healthcare workforce needs of the state. They wanted and envisioned that this body would be guided by some credible, objective workforce data and evidence, and that it would be a collaborative force, really somewhat an entity that would coordinate with existing healthcare workforce entities and efforts and not duplicate them, and an entity that was empowered to convene and align competing stakeholders' agendas and priorities across the state. So these were sort of the principles that the planners had in their mind as they were convening and thinking about this work. Some of the key themes that emerged from those discussions, again, was a very strong commitment to the state's healthcare workforce needs as the central North Star that guided this work versus profession-specific or issue-specific or system-specific, institution-specific wants or interests that the kind of thinking we often have fallen into in the past. The other themes that emerged were just a real need for an action-oriented, a solution-focused entity that was driven by objective data and expertise. Neutrality was another value that kept coming up many times in terms of what they wanted to see this council imbue and really operate as, and the planners really felt convicted that they really valued stakeholder input and engagement along the way, not only while the council was being designed, but also as the way the council executes its work. Some of the inputs that were considered in the design and the structure of the council were around, we reviewed council designs from other states that have been at this much longer. We talked with representatives from 4 states. We talked with folks in Virginia, California, Oregon, Utah, who were very generous in sharing their design, lessons learned and advice and best practices that they had for a state workforce council and how they had been operationalizing it in their state. We also consulted with some national partners, and ultimately we sought some stakeholder input from the state of Minnesota and our residents and interested parties along the design of the council and its duties. So with all of this input and these guiding principles, some of the decisions that were made around the design of this council, we talked about membership, its composition, its size, and the planners landed on this council being a 16-member strong committee, which would consist of 4 legislators. So, part of the idea was we wanted to have the legislators be along with the process right from the beginning. There would also be 2 executive branch agency members and about 10 appointees that would be appointed by the governor, and their expertise would really be reflective of the council's priorities. We settled on a number of 16 advisors. There's no magic to that. It was really, a need to balance representation and diversity of expertise, but also realistic governance. We'd gotten advice from other states to keep the number closer to lower than 20 because it just becomes unwieldy to manage calendars and perspectives and just airtime for people when we have a larger group to kind of put together. In terms of the work done, we knew that every organization, discipline, sector, profession may vie for a seat at the table, and we didn't think that was very realistic. Instead, the planners decided to have standing committees or work groups or ad hoc committees based on the priorities that the council would outline or prioritize, and that would be a way to leverage the rich subject matter expertise that we have in the state of Minnesota, and that was a way for the council to kind of stay nimble and responsive to our priorities. The planners also felt very strongly about the need to be accountable to the legislature and the public, and so to that end, the planners intended for there to be a stakeholder-informed workforce priority-setting process and developing action plans with some kind of regular reporting to the legislature. So in closing, the planners really acknowledged the legislature's foresight in requesting an in-depth consideration of the study on the workforce council, its design, scope, and structure. They underscored the need for impartial thought leadership and a real commitment to meeting the state's workforce needs, as opposed to organizational or professional agendas. And we hope for the authorization of this council so it can work with entities to address the challenging environment we are facing regarding the healthcare workforce landscape in the state today. We stand ready and committed to aid policymakers in answering these questions and any efforts that you have. Thank you for your consideration.
Thank you, Ms. Was it Moibi?
Yes, thank you.
Yes, thank you for your presentation today. Members, there's the 8-3 amendment in front of you. Senator Fate moves the 8-3, hold on. Senate Council?
Mr. Chair, Senator Wiklund and members, I think Senator Wiklund would like to make an adjustment to this amendment that we can do orally, and then it can just be moved as the A3 is orally amended.
Certainly, Senator Wiklund.
And Ms. James, if I get it incorrect, I believe we would like to delete some of the lines. So from lines 1.18 through 2.28, to delete those lines from the amendment.
Mr. Chair and members, and
Yeah,
then
Council.
also on line 2.29 to change the 9 to an 8, and on page 2, line 31, delete the 10 and insert a 9.
So Council, would I need to repeat what you just said there? Council?
Mr. Chair and members know if someone's willing to move what Senator Wiklund and I have jointly described, that would work.
All right, Senator Fate moves the oral amendment to the A3.
The A3 is orally amended.
The A3 is orally amended. And so
Chair.
all those in favor say aye. Aye. All opposed say no. The A3 amendment is adopted. Senator Wiklund?
Mr. Chair, just to confirm, the other parts of the amendment that are remained in the A3 were operational changes that Ms. James recommended that had to do with how the appointing process worked, and then also to ensure that legislative members could receive per diem and be reimbursed for expenses. Those types of things were what were included in the first half of that page. And then we deleted the data section subdivision 8 because after working with the Department of Health, it was felt that the way that they would do the work, the council itself would not be accessing data sources. They would be working with MDH and MDH staff who have the ability to gather data and then assimilate it and then put it in a form that the council would be able to use. So the council wouldn't need express data authority. So.
All right, thank you, Senator Wiklund. Members of the committee, any questions or comments on the bill? Senator Drazkowski.
Thank you, Mr. Chair. I'd like to move the A2 amendment.
Senator Drazkowski moves the A2 amendment, and it's being passed on.
Thank you, Mr. Chair.
Senator Drazkowski, to your amendment.
Thank you, Mr. Chair, members. We have before us, again, another bill that expands government by adding another workforce advisory council in this case, another council, advisory council, legislature. I won't read through all of them this time, Mr. Chair, but by the way, the amendment adds one non-executive branch member appointed by the administrator of the United States DOJ service to the list of 16 people appointed to this brand new advisory council. And the list I read through last time, and Mr. Chair, I won't read through the whole list, but I just want to remind the people of Minnesota that are watching, we had 49 new ones in the last 2 years. There was at least one that went through at the last meeting of this committee. Here's yet another one. There were 283 total advisory type groups that are being paid per diems, that have expenses paid for them, and we're just creating a continued bloating of the bureaucracy here. Mr. Chair, at some point, this legislature needs to do its work and make policy decisions. We have layers upon layers upon layers of government, and as we know, that only leads to fraud. And that's what they're finding out, DOJ is finding out in the federal government. They are exposing the massive fraud through nearly every agency. We know the $611 million of fraud that has solidly been identified and fleshed out here of the humongous government that appears here in the state of Minnesota. We're going to add another layer on here. Let's have a member of the DOJ services on this commission so that they can help sniff out fraud and help those of us that are here that are responsible for the decisions that are made around this table and on the Senate floor, help bring responsibility back to our state government again, diminish the fraud instead of creating new structures that will only create more opportunities for it. I encourage your support. Thank you, Mr. Chair.
Thank you, Senator Drazkowski. To the A2 amendment, seems a hand from Senator Gustafson.
Thank you. Thank you, Mr. Chair. Can everyone hear me all right?
Yes, we can.
Okay. I just wanted to say that while I echo Senator Drazkowski's concern about fraud, it's also something I'm keeping an eye on as well. I just would like to point out that last week we heard from a Republican who had a similar task force proposal, and we did not hear any of these complaints. So it seems like these concerns are only coming forward when they are offered by Democrats. And I would just like to be consistent that we make sure that we are holding everybody accountable. I think that this is a good idea, but I just noticed that we only hear objections on one side. So just want to keep us consistent. Thank you.
Thank you, Senator Gustafson. Senator McQuaid.
Oh, thank you, Mr. Chair. So here we are again, trying to add a member of the douche team to, or whatever they are, to a bill trying to help us with our workforce shortage in healthcare. And unless the plan is to, I don't know, get rid of Social Security and cut a bunch of positions, fire a bunch of veterans, cut the substance abuse and mental health care services funding, gut public health while measles and TB and the bird flu are on the rise, actively engage in open corruption while secretaries of commerce or whomever openly shill for the unelected billionaire and top campaign donor of the president on TV to buy his stock. That is corruption and fraud happening before our eyes. I have no idea what any person who is engaged in actively dismantling our government, firing thousands, tens of thousands of people who serve in the Forest Service and are in the CDC and NOAA and helping us track hurricanes and tornadoes and wildfires, helping us to make sure we can enjoy our beautiful parklands for as long as we have them for, who are providing mental health care for our veterans. They're gonna come in and slash and burn. Senator Wiklund, is that the purpose of this committee? Is it to dismantle our public services and healthcare? Is that the purpose of your bill?
Senator Wiklund.
Mr. Chair, Senator McQuaid, no, I really see this Workforce Council as a way to make sure that we are, as a state, allocating resources where they are needed to bolster our healthcare workforce, which we know we are have scarcity in many parts of the state in terms of care providers and many different professions. And I guess I would just like to say that based on the impact, or based on what we found out yesterday, that over $200 million is now cut off from Minnesota entities being able to use in the Department of Health and in local public health boards, community organizations, grantees, tribal health, tribal nations, health services that was supporting public health infrastructure. It's clear to me that with that type of cut being brought forward and happening right now, that we need to be able to assess very carefully how to best invest in strengthening the healthcare workforce and making improvements. So I think it's, it's just an indication that we are going to be so strapped for resources that we need to make sure that we are analyzing our healthcare workforce very carefully. Thank you, Mr. Chair.
Thank you, Senator Wiklund. Senator McQuaid?
Well, thank you, Mr. Chair, and I think that we should vote no to add douche members to anything in our state government. I mean, they did just cut almost $30 million to serve pregnant women seeking recovery services and behavioral health services in schools. I can't imagine literally anything worse for our society, so we should not add a member of this destructive, corrupt, chaotic, and quite frankly, bonkers douche service to anything in state government, in particular Senator Wiklund's commission.
Thank you, Senator McQuaid. Senator?
Mr. Chair, I would like to
Senator
request a roll call and have the results be printed in the journal on this amendment.
With maybe Senate Council, do we need 3 hands? Do we see 3 hands? Seeing 3 hands, is that a motion? There will be roll call and report in the journal. Staff?
Chair Zhang,
No.
Vice Chair Gustafson,
Oh, Senator Drazkowski, I'm sorry. Senator Drazkowski?
Thank you, Mr. Chair. I was wondering if, the question is whether or not this legislature takes fraud
Sorry,
seriously.
sorry, Senator Drazkowski. We're in the middle of a roll call, but I will give you the floor after the roll call if that.
Oh, that's fair,
Yeah.
Mr. Chair. Thank you.
Sorry about that. It was my fault. Staff, continue on with the roll call.
Vice Chair Gustafson,
No.
Vice Chair McQuaid,
No.
Senator Lang.
Aye.
Senator Barr,
Aye.
Senator Carlson,
No.
Senator Swedzinski.
Nope.
Senator Drazkowski,
Aye.
Senator Fate,
No.
Senator Johnson Stewart, Senator Coran,
Yes.
Senator Miller, Senator Johnson Stewart,
No.
There being six ayes and 7 noes, the motion does not pass and is, oh. Sorry. Was it 2 abstentions, right? I'm sorry, hold on a moment. There being 4 ayes and 7 noes, the motion is not the amendment is not adopted. Senator Drazkowski.
Thank you, Mr. Chair, for your indulgence. I think it may be a sad day in Minnesota when we find that the party in control here seems to belittle efforts to bring fiscal sanity back to the state of Minnesota again. Remember, $611 million in fraud. Not one person has been fired in this government. Not one person. Not one person from that. What does that say about whether or not this government really takes seriously the people's money and the people that were supposed to receive it? $250 million was supposed to go to feed kids. And it ended up in the hands of the greedy people. A bunch of people have already been convicted, and I don't know if we have people that just want to stick their head under the rock here or what, but it's a sad day in Minnesota when we can't take our responsibility seriously. It might not be DOGE that we need to do, but Mr. Chair, we continue to grow this government and create more and more and more committees, more and more liability, more and more vulnerabilities for these types of things, and we don't even take them serious. Sad day in Minnesota. Thank you, Mr. Chair.
Thank you, Senator Drazkowski. Members, any other questions or comments to the bill in front of us? Senator Wiklund, any final comments?
Well, thank you, Mr. Chair. I really appreciate being able to present Senate File 2322 today. I do think that a Healthcare Workforce Advisory Council would be helpful as Minnesota works towards trying to have a better, more comprehensive view of the healthcare workforce needs across our state, and that we have a way to collaborate and coordinate existing healthcare data and healthcare entities that are working on workforce development, as well as just studying, you know, what we have available today. So I appreciate your hearing the bill, and I appreciate members' comments.
Thank you, Senator Wiklund. Seeing no further discussion, Senator Fate moves Senate File 2322 as amended to be recommended to pass and re-referred to the Rules Committee. All in favor say aye. Aye. All opposed say no. The motion prevails. Senate File 2322 is recommended to pass and re-referred to the Rules Committee. Thank you, Senator Wiklund. Next up, we have Senator Hauschild with presenting Senate File 2530. Senator Hauschild, whenever you're ready to go, you may proceed.
Thank you, Mr. Chair and members. All of you probably remember last year we had the excitement around discovery of helium in northern Minnesota. This was exciting because it's the largest concentration of helium found in the world. We don't yet know the volume, but unbeknownst to many of us, the state of Minnesota has never had a gas industry in our state. We've had taconite mining, we've had the prospect of non-ferrous mining, but we have never had any sort of gas. And the good news is that helium is often a fairly clean gas extraction process compared to, of course, things like natural gas and other extraction industries. So we got to work really quickly last year, and I'm grateful to the legislature that worked with us on passing two things. One, a temporary framework for the gas industry, for the helium production up north, or excuse me, helium discovery up north. And we also put into place expedited rulemaking. And so that rulemaking process is ongoing. However, we sort of quickly put that bill together, and now the Gas Technical Advisory Committee, which was created from last year's bill, put together a bunch of recommendations, did listening sessions, had meetings with stakeholders, and presented a proposal of recommendations for how to update the temporary rulemaking, the temporary framework, as well as some of the rulemaking that is ongoing right now. So for this committee's purposes, and council can correct me if I'm wrong, I believe we're looking at Article 1, Section 4, moves rulemaking authority from the Department of Health from the mining statutes to the health statutes and modifies that authority. So that's just a move for the health department on rulemaking. And then I think there's another, there might be another, yeah, Section 13, Subdivision 2 provides permits issued prior to completion of rulemaking do not expire upon those rules being adopted. So when rulemaking is completed, those continue. So those are the only two sections that I'm aware of, unless council has any others that I'm missing. And with that, Mr. Chair, I'm happy to take questions and move on from here.
Thank you, Senator Hauschild. It also looks like we have a testifier that would like to testify on the bill. Oh, Senator Hauschild, a quick question. Council
Yes.
can ask that for you.
Mr. Chair, Senator Hauschild, I'm not sure that I heard both of the rulemaking authority spots that you noted, but I just wanted to make sure you got the one on
Sure.
page 31, section 11. That's subdivision 1 there.
I don't think I did. Which one? I'm sorry,
Senator
Section
Hauschild.
11 and what was it?
Council?
Mr. Chair, Senator Hauschild, on page 31, lines 16 through 19. That's subdivision 1. It's rulemaking for the Commissioner of Health.
Yes, I did get that
Senator
one.
Hauschild.
Yep, I believe I got that one. Thank you.
Thank you, Senator Hauschild. Hello, welcome to the State and Local Government Committee. Please state your name for the record and you may begin.
Thank you, Chair Zhang. Members of the committee, my name is Aaron Clems. I'm the Chief Strategy Officer at the Minnesota Center for Environmental Advocacy, or MCEA. MCEA is a public interest law firm and advocacy organization with over 50 years of experience defending Minnesota's environment and the health of its people, and I want to thank you for the opportunity to testify on the state and local government sections of SF 2530. MCEA has actively participated at every stage of this gas technical advisory committee process. We support the overall goal of SF 2530 to establish a framework for evaluating and making permitting decisions on gas development proposals in Minnesota, and we supported the bill that Senator Hauschild referred to earlier that was passed last year and helped get it passed and helped work on that bill with the DNR and with others. So since we've been following this really closely, I can say quite confidently that the comments filed by tribal governments and conservation groups on the GTAC report have not been incorporated in SF 2530, and this is relevant for the rulemaking process that's about to kick off. There are a number of specific suggestions about environmental review, permit term, control of hazardous materials, and revenue sharing that have not been incorporated here. We understand that in a comment process that not all comments will be incorporated. That makes sense. But when all of them seem to be ignored, it gives the impression that this was not a genuine public comment period, and perhaps worse, not a legitimate consultation with tribal governments. Instead, we're here kind of right now with no movement on a whole host of improvements that would make this framework more protective, workable, and adequate under the law. And this is relevant to the State and Local Government Committee since many of these issues raised in comments in the GTAC report should be included in the rulemaking sections of this bill and addressed in statute regarding temporary permits. In the Judiciary Committee, there was discussion of adding tribal governments to the list of governments that should be able to petition for a contested case hearing, if they have responsibilities related to the proposal. We continue to believe that this addition should be made to the bill. Lastly, temporary permits, as Senator Hauschild noted, should not be permanent, in our opinion. This is another major shortcoming of this legislation as it's currently drafted. Under SF 2530, not only is there no fixed time period for permits, but any temporary permits issued before the expedited rulemaking is completed will remain valid forever unless the permittee applies for an amendment. This provides all the wrong incentives, and it means that any standards that may be developed through the rulemaking process will not apply to a temporary permittee. It would encourage a rush to apply for temporary permits, discourage a permittee from applying for a needed amendment. It's a major reason why MCA cannot currently support SF 2530. We've repeatedly raised this issue through comments, in conversation with the DNR, through testimony, and it remains in this bill. And I believe that any permit issued before rulemaking will rely solely on the statute that's in here, which is why basic public engagement requirements like a public comment period and a requirement that a public meeting be held should also be added to the statute. In summary, SF 2530 as it stands remains prohibitively flawed. We recommend that you reject it if it remains as is. The goal of this bill is good. MCA supports the process throughout and really wants to make sure that there is a bill passed this year that supports a regulatory framework that can be supportive of the gas discovery in northern Minnesota, but also because this applies to all gas development, not just the helium deposit in northern Minnesota, but any potential future hydrogen discovery or anything else. There's things in your packet from the hydrogen industry, for example. It's not just one proposal we're discussing here today. So we would be happy to work with Senator Hauschild to address what we see as major shortcomings in the bill. And I want to thank you for your time, and I'm happy to answer any questions you might have.
Thank you, sir, for your testimony. Before we go to members of the committee, Senator Hauschild, do you have any comments for us?
Yeah, thank you, Mr. Chair. I just want to address some of what Mr. Clems is saying here. First and foremost, tribal consultation did happen through the GTAC process. Second of all, since we've presented this bill, I've had several meetings with tribal governments, with MIAC, and we presented an amendment in environment that was suggested to us by MIAC to address some of the consultation issues as well as burial grounds for the tribal nations. So what Mr. Clems is referring to, I'm not sure. Maybe if he represents tribal nations and wants to say otherwise, that's certainly his prerogative, but I know that I have had conversations and have added several amendments to the bill that have addressed some of the concerns brought by MIAC. He also mentioned that the revenue portion request from tribal governments was not included. That's simply false. They are included. So that's pretty much all I have to say about his testimony.
Thank you, Senator Hauschild. Members of the committee, any questions or comments to the bill? Senator May Quaid.
Thank you, Mr. Chair, and Senator Hauschild. I find myself fully outside of my scope of knowledge, not sitting on any of the environment committees. And I know we're limited to rulemaking here. I guess I'm just trying to figure out what we're rulemaking about. I'm seeing, so gas makes sense. Helium is gas. My science teacher would be really excited about that, that I know that. But I'm seeing oil a lot, gas and oil. We have a definition on 56.15 where we're defining oil. Is that, what's that for?
Senator Hauschild.
Thank you, Mr. Chair, and thank you, Senator McQuaid. I think I will ask the DNR to just clarify what the oil portions of this bill are referring to. And I will also note that in the Environment Committee, we did have an amendment from Senator McEwen that removed some of or a main portion of oil wells from the bill. So I'll get clarification from the DNR, and if we need to keep working on that issue, I'm happy to just confirm I am not looking for anything to do with oil in this legislation. So if there are references to that, I'm happy to work with folks on how we can address that.
Thank you. Welcome to the State and Local Government Committee. Please state your name for the record, and you may begin.
Thank you. My name is Joe Henderson. I am the Division Director for the Lands and Minerals Division at the Minnesota DNR. And so, Chair, Senator, as to oil, the ability to create rules and a permit structure for oil extraction has existed in our rules for years, or in our statutes for years. This package, this recommendation does not allow and does not have the rules embedded within it to receive a permit to extract oil. It's in the title because it's been in the rule ability for years. So what you will notice is that the rules that are portrayed here are about the extraction of gas. There is a prohibition of extraction or production unless a permit is first obtained by the DNR. Through this temporary, as well as the rulemaking that we're moving towards, there is no ability to get an oil permit, so the prohibition in theory would still remain. We're not moving forward at the DNR with the ability to get an oil extraction permit.
Thank you, Director Henderson. Senator McQuaid.
Thank you, Mr. Chair. And Senator Hauschild, I really appreciate it because I know you're not trying to do anything with oil here. And I think we should, I understand, Director Henderson, what you're saying, but the words that caught my ear were in theory, which I don't love. And if we're not trying to do anything with oil, I'm just wondering, like, why would we include it in the new language? And I think I would feel more comfortable taking it out, because then you see gas and oil, and we're defining oil. Even if we've had something in rules for a while, it tells me we're doing something new with oil if we're putting new language in this bill. And I don't love that.
Any comments,
Maybe
Senator Hauschild?
I might be able to clarify, but I'm still willing to work with Senator McQuaid on this, of course. So what I think the DNR is saying is that the portions of this bill that have oil are existing language that we are adding gas to. And so there is oil existing in statute that we're just saying now we are adding gas since we've never done gas. And his statement previously is that we have a prohibition currently in law on oil extraction permits. So you can't get an oil extraction permit in the state of Minnesota. We just have existing statutes that refer to oil, but there is a prohibition on oil. And we're just adding gas to those existing statutes.
Thank you, Senator Hauschild. Any comment? Senator McQuaid.
Thank you, Mr. Chair. It's like I understand the words you're saying, and then I'm like looking back at the bill. So, I'll just give you a random example.
Sure.
If you look at 61.2, when a metal, we're striking or mineral, comma, underline, so new language, gas or oil. And that's throughout. If you go down to 61.29, gross proceeds for
I see what you're
gas
saying.
or oil. And that is, throughout. If you look 62.11, gas or oil are the new words. 62.12, gas or oil. 62.13, gases or oils. That's what I'm seeing that's making me think it's not already in statute because we're adding it.
Senator Hauschild.
Thank you, Mr. Chair, and Senator McQuaid. Good catches. I will pass this to the DNR, but just to add, I think what we're doing is trying to just be consistent with language that's already existing in statute. So yes, you're right, we're probably adding that, but it's just making sure that in all the different statutes that it has the same language. But I will let the DNR answer that. And again, willing to work on this if we need to figure out a way to remove oil. I'm certainly willing to do that.
Director Henderson.
Yes, thank you, Chair. Senator, that is essentially correct. There is no ability to get a permit. There are no rules for getting a permit from the DNR, which must be issued before any extraction can occur. So using consistent language is the attempt that was made here. There is still no path to get a permit because rules don't exist, so essentially there's a prohibition.
Thank you, Director Henderson. Senator McQuaid.
Thank you, Mr. Chair. I think then I would feel more comfortable then if we were just, we have a definition of oil that we're amending in 56.15. Does a definition of oil exist in statute now?
Maybe for Director Henderson.
Chair, Senator, I apologize. I don't know the answer to that right now. I can look that up and get back to you.
Senator McQuaid.
Thank you, Mr. Chair. Oh, man, I'm really uncomfortable. Yeah, okay. How can we fix this, Senator Hauschild? Because I know that, I know this is about helium. What would be your recommendation on how to move forward?
Senator Hauschild.
Mr. Chair, Senator McQuaid, I would be willing to work on an amendment that removes oil so long as it doesn't have some adverse effect that I'm unaware of. I just don't know if council is able to do that at this moment.
Yeah, Senator Hauschild, how many more committees do you know where this bill is traveling?
Good question, Mr. Chair. I think we go to Health and Human Services, and then I believe we go to taxes.
Okay, so maybe in the meantime, you work on this, Senator Hauschild?
Yeah, absolutely, yeah. And
Senator
this was brought up in environment, just to be clear again, and Senator McEwen did introduce an amendment, and I think it was to remove the oil well portion. So we have sort of had this, so I'm absolutely willing to work on this. I think it's something others have concerns about.
Thank you.
Senator McQuaid.
Thank you, Mr. Chair. And Senator Hauschild, I really appreciate that. Happy to work with you on this, although you're a reader. You can read it and find it,
Yeah.
and we'll send it on to Health and Human Services. I would just say, Mr. Chair, I would be more comfortable sending it on without recommendation, just until we have it in the shape that I'm struggling with this sending it, but I trust Senator Hauschild and would be willing to send it. I would just recommend it to be sent with no recommendation.
Senator Hauschild, any thoughts on that?
Mr. Chair, I would just ask I think I'm okay with it, but what does it mean exactly?
Senator McQuaid.
Thank you, Mr. Chair. Senator Hauschild, nothing, and it's how it was sent to this committee, actually, with no recommendation.
Okay,
Senator Hauschild.
that seems fine with me, Mr. Chair.
Certainly. Senator Barr. All right, Senator Drazkowski.
Thank you, Mr. Chair. Maybe I need to bring my drill baby drill amendment. That was supposed to be funny, Mr. Chair. Senator McQuaid? She's laughing.
All right, Senator Drazkowski.
Mr. Chair, so a question for the author. Senator Hauschild, on page 31 of the bill, you have the rulemaking authority. You have given the agencies expedited rulemaking authority, and I'm not sure if you're familiar with it or not, but what that means is instead of the public having a public hearing like they normally do in a regular rulemaking, they don't get one. The public is told you can't have a public hearing in expedited rulemaking, so it relies more on the executive branch agency. You're trusting more in them and less in the people. If you have expedited rulemaking, I'd encourage you to do regular rulemaking unless there's some reason as an author, does this have to happen like super duper quick, or the oil well blows up, or if not, I've got an amendment to fix it and put it back to regular rulemaking if you like, Senator.
Senator Hauschild.
Thank you, Mr. Chair. Senator Drazkowski, we already voted on expedited rulemaking last year. This is just a recommendation from GTAC on sort of the recommendations for updating that. So I would be opposed to that amendment. I mean, we've already sort of moved forward with expedited rulemaking. And it is important to my region, right? We just had 600 miners laid off We don't have the industries and the businesses that many of the suburbs and wealthier parts of the state have. These workers are looking for jobs. Many of the steel workers that were just in town this week are begging us to get the rulemaking done on helium so that there's possible opportunities for this industry and other industries that could come about from it. So it is important to my region. I think it's important to the Iron Range delegation members, and I do want to move forward with what we voted on last year.
Senator Drazkowski.
Thank you, Mr. Chair. Thank you, Senator Hauschild. So, Senator Hauschild, did you ever think that maybe your constituents would want to be involved in a hearing on regular rulemaking, or just be much more beholden to what the agency, in this case, Department of Health, says? They might not like what the Department of Health comes forward with and have no recourse. And because we put expedited rulemaking in the bill, they won't have recourse. They won't have a platform to speak from when the agency comes forward with its proposed rules. And maybe Ms. James, Mr. Chair, does she know how much longer the regular rulemaking process is than the expedited one?
Council, Ms. James?
Mr. Chair and members, typical full rulemaking process is 2-ish years. But I don't know what process or what timeline their expedited rulemaking is on right now.
Senator Drazkowski.
Thank you, Mr. Chair. Well, I would offer the A9 amendment. We'll see what happens, Mr. Chair.
Senator Drazkowski offers the A9 amendment, and it is being passed out to the members. Senator Drazkowski, would you like to go over your amendment?
Yeah, the amendment simply, and I would amend the amendment because I'm not sure of what it means the way it's written. I would strike the words 2 and 20 and insert the words and 19. So it would read delete lines 18 and 19 on 1.3 of the amendment. So what it does is it keeps the first sentence after rulemaking authority and deletes the next 2 sentences and finishes its deletion right before line 31.20, Mr. Chair.
All right, thank you, Senator Drazkowski. Council, maybe Ms. James, you can reiterate the oral amendment.
Mr. Chair and members, on the A9 amendment on page 1, line 3, delete 20 and insert 19.
All right, thank you, Senator Drazkowski, for your oral amendment. Senator Hauschild, do you have any thoughts on the amendment here?
Thank you, Mr. Chair. Again, we already went through this. We voted on this for expedited rulemaking last year. It was something that was overwhelmingly voted on in favor of. And this is something that's really important to northern Minnesota to make sure that we have this industry up and running. Right now, the well is on private land that is doing discovery drilling. We put into place this sort of rulemaking process and the moratorium on production of helium so that we could get this all in place and make sure that we're benefiting from it as a region. And so I don't feel like revisiting it is the right move, but I'm happy to tell the Senate Republican colleagues on the Iron Range delegation that this move is being made. I don't think people will take kindly to it, and I would strongly oppose it.
Thank you, Senator Hauschild. Members, any other additional comments on the amendment? Senator McQuaid.
Thank you, Mr. Chair, and I would also urge a no vote. This just says gas wells, so that is not, there's nothing wrong with that. And Senator Hauschild, I think, you pointed out 600 folks have been laid off in your area. That's a lot of people who are out of a job, and to wait 2 years to go through this after we've already voted on it, just not sustainable. So I also urge a no vote.
Senator Drazkowski.
Well, Mr. Chair, it's a year later, and I would ask for a roll call.
Senator Drazkowski requesting a roll call. Roll call will be given to the A9 amendment as amended, orally amended, as amended. Council will take, staff will take the roll.
Chair Zong,
No.
Vice Chair Gustafson,
No.
Vice Chair McQuaid,
No.
Senator Lang,
No.
Senator Barr,
Aye.
Senator Carlson,
No.
Senator Swadzinski.
Nope.
Senator Drazkowski,
Aye.
Senator Fate,
No.
Senator Johnson Stewart,
No.
Senator Curran, Senator Miller,
There being 2 aye votes and 8 nay votes, the amendment is not adopted. Thank you. Members, any other questions or comments on the bill? Senator Carlson.
Thank you, Mr. Chair. I have 2 amendments that I'd like to offer. I have to apologize to Senator Hauschild because these came up at the last minute. I think they may have been covered with you by your staff. But I'll offer the A11 amendment first.
All right.
I think we have copies that we can
Yes, we
hand
do,
out.
Senator Carlson. Senator Carlson, to your, I think the A10 amendment is being passed out right now.
Okay.
And, well, A10 and the A11. Senator Carlson, to your A11 amendment.
Okay. Thank you, Mr. Chair. The A11 amendment deals with the permit and has it expire after 3 years. So it does not, the initial permit does not go on forever. And where that goes is in page 16, line 31, where it says it does not expire, and it expires after 3 years after it is granted. And to help explain this, Mr. Clems is aware of this amendment and helped us get it drafted and positioned in the bill. And I have to ask Senator Hauschild if he is open to having this amendment added. And I think he's already passed that point in their permitting process.
Senator Carlson, that's it?
That's it for the 11th.
All right. Senator Hauschild, any responses to the A11 amendment?
Mr. Chair, I didn't get a chance to talk to Senator Carlson about this directly, but, you know, the company has been going through the process with the agencies on these discovery drills. They've followed the process. Everything has been going very smoothly from what I've talked to with the health department, DNR, all the different agencies that are involved. There has not been any issues brought up with regards to what they've done through the process so far. I don't see a need to do an expiration of these permits if they've followed the process and have gone through it the right way. So in my opinion, I don't think this is necessary and I wouldn't support it.
Thank you, Senator Hauschild. Members of the members, any questions or comments on the amendment? Senator Johnson Stewart.
Thank you, Mr. Chair. My question is for Mr. Clems, I think it is. Why is this an important amendment or not?
Mr. Clems.
Senator Johnson Stewart, Chair Zhang. As written, temporary permits that are issued before rulemaking is completed will remain valid in perpetuity. They will never expire unless the permittee applies for amendment or they violate the terms of the permit. As you know, in the rulemaking process, you develop a lot of different standards and a lot of specificity that are reflected in future permits that are issued to applicants 5 years down the road. As written, those standards that are developed through the expedited rulemaking process would never apply to the temporary permittee, assuming that they were above and beyond what the temporary permit would be, which is a fairly safe assumption. I mean, there's fairly broad brushstrokes about what the temporary permit would look like. We would expect the rulemaking process to really fill that in. By giving the permittee who has a temporary permit 3 years to get an actual permit that's established through the rulemaking process, it seems like a reasonable amount of time. It provides regulatory certainty to the folks that are going through that process. This is not at all saying that that Pulsar, the company that's in question, is doing anything wrong. They're not. It's more about, we have a temporary permit system in place to try to expedite that process and get them up off the ground, and that's fine. But that shouldn't remain in place as a temporary permit forever. It's not a temporary permit, that's a permanent permit. And so that's why we think it's an important amendment, and we thank Senator Carlson for offering it.
Thank you, Mr. Clems. Senator Johnson Stewart, any follow-up? Senator McQuaid.
Oh, thank you, Mr. Chair. Again, with my unfamiliarity with this part of state government, is it possible that somebody could receive a permit while expedited rulemaking is happening, and after expedited rulemaking happens, that the permit that they have, they're doing all the things that are covered in, that the rules said? And is it possible to have, I guess what I'm saying is that I'm not totally uncomfortable with it being permanent if all the rules that were adopted were part of the permit that they have already, I guess is what I'm trying to say. Is there room in here for that?
Senator Hauschild.
Chair Zhang, Senator McQuaid, I don't know the answer to that explicitly. I can refer to maybe the DNR could explain why this was the recommendation.
Director Henderson, maybe the question is maybe if,
The original intent, I mean.
yeah, if the rules, permanent rules would be morphed into the temporary permits, is that what you're looking at, Senator McQuaid?
Or Mr. Chair, like if somebody issued me like a temporary license pending a background check, and then I've passed the background check, my license could just become a permanent license without me having to like I've met all the criteria while they were checking it out. Is it possible that the temporary permit meets all the conditions of the final adopted rules, and therefore a new permit isn't required, it just becomes a permanent one, or whatever?
Thank you, Senator McQuaid. Director Henderson.
Yes. Chair, Senator, you can imagine situations where the temporary framework could be more stringent. You could imagine situations where it may be less. And yes, it could be true that it could align perfect, and that a temporary permit, as Aaron Clems had said, someone comes in for an amendment, during that amendment to increase a footprint or ramp up their financial assurance, that amendment could issue then a permit under the rule, if the rules are in place, right? Or the agency at its discretion could modify it to align with the rules. And so absent the rule process right now and knowing where it's going to differ, we put in place a system where the permits would not be pulled away from an industry. They would be allowed to operate until the rules were in place, and then if an amendment came, they would need to meet the rules as they were approved. And we don't know how many permit applications or requests we're going to have, so we gave the space to be able to manage those as amendments come in.
Senator McQuaid.
Thank you, Mr. Chair. I guess what I could imagine a world where they were more stringent or less stringent. And in the world that I'm imagining, the permit that was issued temporarily under more stringent rules, it should continue to be after the rules are adopted. But if it was issued under less stringent framework, but then it remains permanent, and we have rules that are saying that it needs to be different, I don't know why we would not redo that. And so if they match up perfectly, great. If the temporary was more stringent, great, then everyone's in compliance. But I do think that there's room here to say, if we somehow come up with a framework that there's rules that you need to comply with, if you're now applying, but somebody was in earlier and they're not complying, I mean, we're just like not even abiding by basic competition rules and capitalism. So that's kind of where I'm landing.
All right, Senator Hauschild.
Mr. Chair and Senator Mayquade, I think it's tough to give a sort of black or white analysis of exactly which parts of the rules will be more stringent or which ones might be less stringent. I think there's a lot of rules, right? So there's not like a clear answer on that. Would be the struggle with determining that, I think. I mean, I'm not an expert in this, but that's my understanding. The other thing to note is that the DNR has the opportunity, if it were the case that the rules became way more stringent or something was different about the project, they always have the opportunity to reopen that permit and have it analyzed and redo it. And I think from what we've seen through the GTAC recommendation process, it feels like this one discovery well, which is a very small area so far because the industry has, is only in discovery phases. The agencies through their recommendation process felt like that one well could be grandfathered in, that there are, that this industry will grow from here, but that things seem to be going really well with this well, and there's no issues that have been brought up with it.
Senator Johnson Stewart.
Thank you, Mr. Chair, and thank you, Senator Hauschild. My question is for the DNR. So what activities does a gas resource development permit cover? And the reason I ask is because I'm concerned if the permit is up for renewal, what happens to the mining operation? Does the permit cover the mining itself, or does it cover, this word development has me questioning what that permit is.
Director Henderson.
Chair, Senator, based on my knowledge and my knowledge of permit to mine in general for ferrous and non-ferrous as well, the permit to mine, in this instance, the gas resource development permit, would be for the site, right? It's operations on the site, it's reclamation of the site, it's the management of that site and the extraction of the gas from that site.
So,
Thank you, Senator Johnson Stewart.
Thank you, sorry. So it's not development of it's not the pre-design, the pre-development, it's in fact the actual operations. And so it's the operations of the.
It is the site.
Director Henderson.
And Senator Hauschild,
Senator
thank you.
Johnson, sir.
Thank you. So your point about the permit can be reopened at any time, would the DNR just confirm is that, again, I'm concerned about business getting interrupted. Is that a disruptive situation? Does that happen very often? How would that impact the mining operation itself, if in fact the permit was reopened, or if the company had to apply for a new permit?
Director Henderson.
Chair and Senator, in specific instances, using mining as another example, right? In terms of a modification, the company gets to continue to operate as they're permitted, not including the modification that they intend to get until the modification is received. That modification will have to go through the public process to be able to then have the ability to do what they hope to do. So you have to propose, you have to go through the process, it has to be approved, the DNR would have to agree that they believe it meets all the existing laws and requirements. Before then, we would issue the modification, the amendment, and then there are opportunities for appeal on that if people don't believe the decision the DNR made was legal.
Senator Johnson Stewart.
My understanding then is that having the permit become permanent is not really permanent forever. It
Right.
allows for amendment and review by the DNR, correct?
Director Henderson.
Chair, Senator, that's correct. The company could come in with a modification, or in specific instances that are also outlined, that's called an amendment when a company comes in. The DNR could take a unilateral action under certain instances to modify without an application in front of us.
Senator Johnson Stewart. Senator Carlson.
Yeah, thank you, Mr. Chair. So I guess what I'm hearing is that temporary is just, you could say that the permit is permanent if we don't have this temporary language added to it. It's temporary until someone wants to modify it. So it really is, there's it's an opening for either side to be able to increase or decrease the controls of it at their request. So what I guess, Mr. Chair, what I'm thinking is that it looks like the need for this amendment is not very high, and so I would withdraw the amendment.
Senator Carlson withdraws the A11 amendment. Senator Carlson,
Yes.
you're to the A10 amendment.
Thank you. I also have the A10 amendment, and that's a very, very simple one that adds just one word, and it is just a recognition of some historical facts in the area. I have to get my description out here, but it's to add to Senate File 2530 that we include tribal governments among the list of governments that can petition for a contested case, a hearing, or that they must be involved in the oversight of the application for a gas resource development permit.
All right, thank you, Senator Carlson. Senator Hauschild to comments on response to the A10 amendment.
Thank you, Chair Zhang, and thanks, Senator Carlson. I'll say this. Through the Gas Technical Advisory Committee process, tribes were consulted and letters were sent. You know, there was official correspondence on the concerns that they had. In addition to that, I have met with MIAC a couple of times, as well as some of the tribal nations that I represent, and this issue has not been brought to me. It's not necessarily that I'm opposed, but it does change law that exists. It changes law for gas that is different from, let's say, taconite or non-ferrous. And because this, from my understanding, is not being brought by MIAC or the tribal nations, I would oppose it at this time because I'd like to consult with them and have more time to determine what specifically their requests are. But like I said, the amendments that they brought me to add to the bill have been added in environment. Two of the specifics, not all of them. There's, you know, we're sort of working through the process, but two of the main things that they asked for were included. And so at this time, I would oppose this, but be willing to continue to work with you and others on this.
Senator Carlson.
Yes, thank you. I think what we need to do, we've made mistakes in the past, not including tribal representation, and I think we have to kind of put an end to that, not including them, because this is their homeland, and I think they should have a voice in it right from the beginning. So I'm going to continue to support the amendment.
All right. Is there a motion, Senator Carlson?
Oh, yes, Mr. Chair, I'd like to move the A10 amendment.
Senator Carlson moves the A10 amendment. All those in favor say aye.
Aye.
All those opposed say no. No. The amendment is not adopted. Senator members, any other questions or comments on the bill? Senator Hauschild, final comments.
Mr. Chair and members, I appreciate the in-depth conversation. I know we still have more work to do on oil that was talked about here, so I will work on that issue and we'll keep working through the process. I really appreciate the in-depth conversation.
All right, thank you, Senator Hauschild. With that, let's see here, hold on a moment there. Seeing no further discussion, Senator Swedzinski moves that Senate File 2530 be recommended, Senate 2530 be re-referred to the Health and Human Services Committee. All those are recommended to pass and re-referred to the Health and Human Services Committee. All those in favor say aye. Aye. All opposed say no. The motion passes. Senate File 2530 is recommended to pass and re-referred to the Health and Human Services Committee. Next up, we will be going back to Senator Latz's bill. Senate File 1492. Senator Latz, whenever you're ready, you may begin.
Thank you, Mr. Chairman and members, and I appreciate the agenda accommodation as well. Senate File 1492 proposes to establish a civil commitment coordinating division within the Minnesota Attorney General's office to establish an advisory committee for that responsibility. And is intended to fill a gap and gather information in our civil commitment system. Before I explain that any further, I would like to thank my co-authors on the bill, Senators Draheim, Abler, Utke, and Hoffman, and also the co-signatories on a recent op-ed piece that we had published in the Star Tribune. Senators Draheim, Abler, Utke, Carla Nelson, Nick Frentz, John Hoffman, Chairman Zhang as well. Appreciate the broad-based support for this. The need for this was brought to my attention by Professor Larry Jacobs at the University of Minnesota Humphrey Institute, by Norman Ornstein, who a Minnesota native who has become a national expert on mental health issues as his family, his son Matthew struggled with it and ultimately lost that struggle as well. Representative Mindy Greiling, whose child has severe mental illness and has been an advocate since she was a state representative years ago when we served together in the House and since. We started investigating why there were gaps in the civil commitment system. People falling through the cracks, especially those with such severe mental illness that they were incapable of understanding that they were mentally ill. So they don't recognize that they have a problem that needs to be addressed, and the system is left to care for them or not. And what's happening in too many cases is that the system is not caring for them. This mental health system in Minnesota has terrific laws. It's recognized as one of the best in the country. Unfortunately, too many people are still falling through the cracks. DHS is primarily responsible for dealing with civil commitments. I had some intersection with it years ago when I was in the Attorney General's Office Human Services Division and getting Jarvis orders for state hospital patients, the neuroleptic medication orders, and dealing with mentally ill and dangerous appeals as well. So I'm circling back now, later in my public service career, to focus particularly on people with anosognosia, those who lack insight into their illness. So they won't accept treatment on their own. They may end up in civil commitment, but often there isn't space for them. Sometimes they end up in our criminal justice system in the jails or the workhouses, which is the largest single institution that houses mentally ill people in Minnesota, a system that is ill-equipped and not designed for that purpose. Or people get civilly committed and then don't have a place to go, and they end up out on the street and homeless, which was part of the story that was reflected in our op-ed piece, where a person ended up homeless, sleeping in an alley, and while he was there, he was driven over by a garbage truck who didn't see him there. So we need to do better in Minnesota, and this is one proposal to accomplish that. The coordinating division would be tasked within the Attorney General's office with maintaining the Civil Commitment Advisory Committee, with providing best practices and guidance to courts, counties, designated agencies, treatment facilities, and community-based treatment programs, with advocating for increased statewide capacity for engagement services, outpatient civil commitment, and provisional discharge, providing technical assistance to local and regional bodies tasked with monitoring civilly committed participants, with filling what is a substantial data gap in Minnesota. We don't even know how many people are out there civilly committed but not well monitored. We don't know how many people are waiting in our hospitals, in the emergency rooms, or in our jails to be discharged to facilities. So we don't know what the shortage is of those kind of safe places for them to go and to receive necessary treatment. To analyze this data submitted by all of the jurisdictions, of course, to make sure the data is maintained according to Chapter 13, to create a public awareness campaign to educate the public about the availability and effectiveness of engagement services. Since this proposal has actually been around for about 3 years now, and this year I'm pleased that we are gaining traction as well on it. The original proposal had a civil commitment advisory committee which contained a number of members. Since it was originally proposed and based on input, we have expanded the membership on that committee. And the amendment that I'm going to ask this committee to add adds one more member, the Minnesota Competency Attainment Board Program Administrator or Designee. And that request came in from the Competency Attainment Board themselves today. So we've incorporated that into the request to add here. Based on input received from NAMI Minnesota, we are also proposing in the A7 amendment to delete the grant programs that are contained in the original bill because they are already existing and there's funding in process for those two grant programs.
Senator, we're going to pass out the A7 amendment for members here as you're going through it right now. Senator Latz.
Thank you, Mr. Chairman and members. The original bill has a diversion study grants and engagement services, outpatient civil commitment, and provisional discharge grants. Information received from NAMI and Sue Aberholden have indicated there is no additional need to have that in my proposal, so the amendment would delete both those a new establishment of those grants and the appropriations that would go into those grant programs. And then finally on this amendment, in response to a request from Mental Health Minnesota that's been working on a transport hold work group, the amendment proposes to establish such a work group and with a diverse membership. These are people that are involved when people come to the attention of law enforcement principally, and which is a lot of the entry point for a lot of people who are mentally ill in Minnesota. And they're charged with safely transporting and committing them to holds, usually in hospitals. And so they have asked that we establish a work group to try to figure out best practices there, including some use of force guidance to handle that. And that's a limited time work group that would expire in February 2026. So I would ask someone on the committee to offer the A7 amendment.
All right. Senator Carlson moves the A7 amendment. All those in favor of the A7 amendment say aye. All opposed say no. The A7 amendment is adopted. Senator Latz.
Mr. Chairman, I do appreciate the input that we've received as this bill is working its way through the process. It's my intent to ultimately have it be returned to the Judiciary and Public Safety Committee where we would, my goal is to find the funding to fund this civil commitment position or division within the Attorney General's office. With that, I'd be happy to stand for questions and answer.
All right, Senator Latz, looks like we have a testifier that's also here to testify on the bill. Thank you. Welcome to the State and Local Government Committee. Please state your name for the record, and you may begin.
Thank you, Mr. Chairman. Members, Sue Abderholden, Executive Director of NAMI Minnesota, the National Alliance on Mental Illness. We are a statewide grassroots organization dedicated to improving the lives of children and adults with mental illnesses and their families. And I'll just note that nearly 100% of our board staff and volunteers either live with a mental illness or have family members, and I have family members. We appreciate that yesterday Senator Latz met with a member of my staff and Shannon Mulvihill from Mental Health Minnesota to talk through the bill. We appreciate that those changes were made today. We still have some lingering concerns that some of this might be duplicative with what the Department of Human Services does as well. The Department of Human Services is named actually as the state mental health authority, and then each county in Minnesota acts as the local mental health authority. There are several advisory committees that are kind of meeting on these issues, really facing the implementation of the Commitment Act and the development of our community mental health system. This includes the Priority Admissions Panel, which is actually where the transport hold idea came through. We also have the Mentally Ill and Dangerous Task Force that's looking at the number of commitments throughout Minnesota, which is about 4,700 a year. And then we have the State Advisory Committee on Mental Illness as well. In terms of diversion from the juvenile or from the criminal justice system, 21 counties in Minnesota are already involved in what's called the Stepping Up Initiative, where they use what's called the sequential intercept model to identify how to divert people with mental illnesses from the criminal justice system, starting at when a crisis occurs all the way until they're in prison. Due to the sparse population in some counties, we have the adult mental health initiatives, and we have 19 regions of them, and covers all the counties, and they use state grant funds to fill gaps in coverage, including services and supports that aren't covered by insurance. Their goal is to provide consistent and effective care for people with serious mental illnesses. The Attorney General's office, is not the mental health authority. Frankly, they do lack some expertise to address the myriad issues facing people with mental illnesses. I will note that the Ombudsman for Mental Health and Developmental Disabilities contains the Civil Commitment Training and Resource Center, and that center was developed to assist persons who want training and information regarding the Civil Commitment and Treatment Act. I will say that NAMI Minnesota takes thousands of calls every year on a wide range of topics. I take them personally myself. And what we're seeing in terms of the Commitment Act is the biggest one is that police not willing to do transport holds due to the changes that were made in the use of force law. We also see people being discharged while committed to shelters because housing isn't available, and because they have a bed in the hospital means that they don't go to the top of the priority list because they have a bed. We have huge workforce challenges in Minnesota with community and counties finding it hard to even hire and train case managers. And then if people don't follow the treatment plan under the Commitment Act, hospitals won't take them unless they meet medical criteria, and otherwise there's nowhere else to take them. Over my 20-plus years at NAMI, I have been involved in countless task forces and committees that have involved all the relevant viewpoints and put forth solid recommendations to build our mental health system. The real reason that people fall through the cracks is actually because the legislature has not funded our mental health system. Every year, NAMI and the Mental Health Legislative Network, which is a coalition of over 40 organizations, bring to the legislature bills that we believe will actually build our mental health system. The work to build our mental health system is ongoing. I'm not really sure that adding another committee in an agency that does not oversee or fund the mental health system will necessarily help. We're committed to continue to work with Senator Latz, but again, the biggest problem we have and why people fall through the cracks is because we have not funded our mental health system. And I'd be happy to take any questions.
Thank you. Members, any questions or comments on the testimonies? Seeing none, Senator Latz, do you have any? Senator McQuaid, sorry.
No, it's okay. Thank you, Mr. Chair. Senator Latz, I'm inclined to agree with Ms. Abderholden, only just, we sit on, Senator Fate and I sit on the Human Services Committee, and we spend a lot of time talking about this issue in that committee, and direct care and treatment, and caddy waivers, and transport holds, and non-emergency medical transport holds, and boarding, and backlogs, and all that kind of stuff. And so I think I'm just really hesitant to put the Attorney General's office in charge of a piece of this because it is so complex, the problem, and it often comes back to capacity, lack of funding, and workforce shortage. And I very rarely do I feel like I could produce a report for a committee. This might be one where we've had a lot of pieces that they would put together. And so I'm sitting here with a little bit of, when you have all of the mental health folks that come and do this advocacy saying like, this might not be the best way, that does give me pause. But I agree, like we're failing folks, we are. And I do think the legislature is not responding to the needs as they're being given to us from advocates, from people who are living, with mental illness and telling us what they need. And also counties. I had my county in my office today saying, hey, our system's really old and we have to like put in a code. Anyway, so that's just kind of what I'm sitting with here is we haven't really talked about this issue in this committee that much because it just, not a lot of it happens in this committee. A lot of it happens in human services. So I'm going to sit with that for a little bit. Thank you.
Thank you, Senator McQuaid. Senator Barr.
Thank you, Mr. Chair. What's the path for this bill, please?
Thank you, Senator Barr. It will be laid over for possible inclusion.
Thank you.
Senator Barr.
The question then begs, I notice on lines, starting about 616 through the end of the bill, we've got a lot of dots for funding. And I'm guessing that that'll be plugged in before we move that out of here then, right? Or included in the omnibus bill? That'll be coming out of our budget, correct? Or the Attorney General's?
Yes.
Okay, thank you.
All right, any other questions or comments on the bill? Senator Latz.
Thank you, Mr. Chairman. I guess I'll ask also for a little bit of clarity whether it's your intention to lay it over or the intention was to move it back to the Judiciary Committee where I will take on the budgetary implications of it. So I guess that's my first question.
Senator Latz, if that is your wish, we certainly can make a motion.
That would be my request, Mr. Chairman. And I also have just a follow-up to Senator McQuaid's
Senator Latz.
comment, if I may. First of all, Attorney General Ellison has been on board with this for over a year now in terms of supporting this initiative and moving this initiative into the Attorney General's office. When we were trying to decide where to best locate this, we were considering really three options: DHS, the judicial branch, which will be an important component of addressing all of these, and the Attorney General's office. We concluded that DHS, with all due respect, there are a lot of problems with the existing system, and they have been there for a long time, and I think it's time for a fresh pair of eyes and a fresh location, maybe a little more objective or outside view on this to gather data, which we don't even have enough of right now, as well as to provide some of the other services that are itemized here, which may not necessarily need legislation. DHS hasn't done it up until now. As far as I'm aware, I'm not being told that the tasks in here are being duplicated in DHS right now. We also decided that within the judicial branch, it would lead to less legislative oversight to some degree because once you put something in the judicial branch, they tend to take it over. And also because I think it's better to have, again, an outside view with guidance being and suggestions being brought to the attention of the judicial branch, which would be an important partner in resolving this. But ultimately, I really think it's important to have a separate eye from the existing agencies working on this and tasked as indicated here. And then that would give us, and it would give a responsibility to the chief, where the civil law tends to reside in our state and the Attorney General's office to focus on this as well, because there is so much intersection between the civil justice, civil commitments, and the criminal justice and the civil justice system that I think that's an appropriate location for it. Thank you, Mr. Chairman.
Thank you, Senator Latz. Senator Carlson moves that Senate File 1492 is recommended to pass and be referred to the Judiciary Committee. All those in favor say aye. Aye. All opposed say no. The motion prevails. Senator Latz, the Senate File 1492 is recommended to pass and referred to the to the Judiciary Committee. Thank you.
Thank you, Mr. Chairman and members.
Next up, we have Senate File 286, Senator Howe. Oh, House File 286, Senator Howe.
286.
Senator Howe, whenever you're ready, you may begin.
Well, thank you, Mr. Chair. We're doing the House file. Great. House File 286, what it does is that right now when we do background checks for massage parlors or cabarets, what they do is just a state background check. What this would allow us to do, we'll do a fingerprint and a federal background check to go a little bit deeper. What we've found is doing the state background check just doesn't check everything. We've got applicants for massage parlors that have fabricated their credentials, and we're not finding those items that call for it. We've had the experience in a jurisdiction where I work where out of 4 massage parlors, we shut down 3 of them for human trafficking and sex trafficking. So we're looking for a little help. There's letters out there from the Minnesota Chiefs of Police and from the League of Minnesota Cities. I don't believe either one of my testifiers are available, who are also law enforcement, but that is where the issue is, and that's what this allows cities and counties to do, is do a more thorough background check on the federal system, because many of these programs go from state to state, and that's what we're looking for.
Oh, all right. Thank you, Senator Howe. And looks like the testifier is online with us.
Great.
Please state your name for the record, and you may proceed with your testimony.
Thank you, Mr. Chair. I'm Anthony Rezacek. I am the Chief of Police at the Way Park Police Department. Thank you for your time today. This House file, as Senator Howe was explaining, addresses a couple loopholes within the vetting process for licensing massage therapists and the establishments. So like many other cities, we adopted a city ordinance to help with local licensing requirements to these. We currently have 17 licensed facilities in the city. The current background system, the rules require us to use the Purpose Code E. The Purpose Code E only allows us to see a very narrow glimpse of that person's background. Purpose Code E allows us to see any adult arrest data that is less than 1 year old and any adult convictions, but only in Minnesota. As the senator explained, we've had a history in Way Park where we've had establishments that were doing illicit activity. Part of our vetting process, we've had to use other online resources to try to vet some of our applicants. And the problem is we really can't see a good picture of who these people are. And the problems we face are, without being able to do a fingerprint background, we are really limited on being able to confirm names, making sure that that person hasn't provided multiple false names. We've had issues where the address on their education certificates came back to vacant lots in LA and all around the country, and there's no way to really go back and find who these people are and if they're a legitimate licensed masseuse, and that they are of the character that we would want operating these establishments. By allowing us to do a full fingerprint background would be able to give us that viewpoint where we can see if they've had prior contacts in neighboring states or anywhere in the country, if they've had prior prosecution issues for illicit acts, and give us a much better understanding of who it is that we are vetting and saying are licensed and licensed through our city. And without any other state level regulations, this is what every jurisdiction really would need to be able to put a little bit of trust in that licensed business type of branding as we require. Thank you for your guys' time. I appreciate it.
Thank you, Chief Rezicek. Members, any questions or comments on the bill? Senator McQuaid.
Thank you, Mr. Chair. I just have a few questions because I'm not familiar with the city, city licensing processes. Is there a specific, like when you apply for a license for a business, is like massage services a type, or you just say like, I'm opening a business and here's the type, or?
Senator Howe?
Thank you, Mr. Chair and Senator McQuaid. All cities have that a little bit different, but for massage in the cities that I'm familiar with that work with this, massage therapists and massage parlors are a separate license specifically for those. They actually license the individual and the business. So it's two separate licenses, one for the parlor, one for the individual providing the service.
Senator McQuaid.
Thank you, Mr. Chair. Thank you. I appreciate that. That's helpful. And then my only other question is, does each city have like a set of criteria that or a set of things where they say like, if this, then no license? And do we know what all of those things, like, I guess what I'm wondering is what things are going to come up on background checks that then cities will say like, no, we're going to deny a license, because we're not really limiting it here. And so I just want to be really sure about what that is.
I can.
Senator Howe.
Thank you, Mr. Chair. Many times, what they do is they verify where they've got their certificate of training, where they've got this. But I'm sure, as the chief of police stated, is that we've had them give fake names, a lot of stuff that is really fraudulent, and they've got really no way to check it if they're only doing the state. So all of that is a piece of that pie, that investigation.
Senator McQuaid.
No, thank you, Mr. Chair. And I guess, Senator, what I'm trying to get at is, I hear the story from your district, and I'm just wondering if there are specific crimes we need to list that if they come back as having been, arrested, charged, convicted of those crimes, then folks can deny licenses. And I see we have, I think, the chief raising his hand that might be able to give more clarity as well. I just want to know.
Sure, certainly.
Yeah.
Chief Rezicek.
Thank you, Chair, and thank you, committee members. Just to try to put a little bit more clarity, the purpose code E that allows us to run the background checks, that is governed by state statute 299C.77. That applies to any licensed or non-criminal justice positions within a city. So like volunteers, things like that, all get ran under that same purpose code because that's what is statutorily defined. Hopefully that puts a little bit of clarity on that question. The other piece is, yes, every city has a different set of standards that they can deny a license for. Again, most language, because it's all written by lawyers, is pretty in line with the behavior that would be illicit in that type of activity. So we're not looking to see if they've ever been charged with shoplifting or driving without a license. We're looking at violations of illicit, like sexual conduct, prostitution, things like that, for that particular license. Thank you again for your time.
Thank you, Chief. Senator McQuaid.
Thank you, Mr. Chair. Thank you, Chief. That was really helpful. I appreciate the clarification.
All right, Senator Howe, any final comments?
No, thank you, Mr. Chair, for allowing us to hear the bill, and thank you for the committee for the time.
All right, seeing no further discussion, House File 286 is laid over for possible, Senator Howe.
Mr. Chair, I think the other bodies already passed it through. Could we send it to the floor and move it through?
Did you hold on a moment, Senator Howe? Senator Howell, certainly. Council, would we need a motion from a member of the committee then? Senator Swedzinski moves that House File 286 be moved to the recommended to pass and move on to the recommended to pass, move to general orders.
Thank you.
All right, Senator Howe, thank you.
Got to vote.
Yeah, all those in favor say aye. All opposed say no. The motion passes. Thank you,
Mr.
Senator
Chair.
Howe. All right, next up we have Senator Pa, Senate File 1464. All right, Senator Pa, whenever you are ready, you may begin.
Thank you, Chair Xiong and members of the committee. I appreciate the opportunity to present 1464. I want to recognize and thank Senator Barr. I don't know if he's here today. Yep. Senator Barr, for being a co-author on this bill. Chair, I do have an amendment, the A7.
All right, certainly. Senator Pa, would you like to move the amendment now, or would you like to speak on the amendment?
So the amendment has 4 notable changes on there. One is asking that the Commissioner of Natural Resources must provide subject matter resources and expertise. The other one is adding that the task force must elect a chair at its first meeting among the members of the legislative members. This was a suggestion from the LCC from previous task force that they've worked on. The other one was adding that the report must detail the proposal for changes as detailed below here. And then the last one is adding a subdivision for per diem for expense reimbursements and compensation to members of the task force.
All right, thank you, Senator Pa. Senator Carlson moves the A7 amendment. All those in favor say aye. Aye. All opposed say no. The A7 amendment is adopted. Senator Pa, you have any additional comments?
Yes, so I'd love to speak about the bill. This bill proposes the establishment of a sustainable foraging task force to provide the legislature with recommendations grounded in traditional ecological knowledge, science, and data. These insights and recommendations will give us as lawmakers a solid foundation for making informed policy decisions when it comes to foraging, and not leaving that decision to our department through rulemaking. The task force will bring together a diverse group of experts and community stakeholders, including the DNR. It is essential for us to support access to our public lands and for foraging wild foods and medicines, rather than imposing barriers and restrictions that prohibit Minnesotans from enjoying our state's natural resources. Minnesotans have enjoyed foraging sustainably for hundreds and hundreds of years. And today that is at stake because there are proposed restrictions that would prohibit foraging. And so this is why we're asking for this task force. Thank you, Chair.
Thank you, Senator Pa. We'll open up to our testifiers here. Is it Ms. Erickson?
Sure.
Please state your name for the record and you may begin.
Thank you. Mr. Chair, Senator Pa, members of the committee, my name is Tara Erickson, and I'm a member of the Minnesota Mycological Society. I've worked in government relations and public affairs for 25 years, and I'm volunteering my time to lead the advocacy around this legislation. Thank you for allowing me to testify today. This legislation is a few years in the making. Around this time in 2023, I found out about possible new regulations severely limiting foraging activities in state parks by reading a Minnesota Mycological Society newsletter, and I immediately contacted the organization to understand what was happening and if I could be of assistance. What I found out was that at the time, the Minnesota DNR had refused to meet with any stakeholder organizations, and these folks were very nervous and scared about the possibility of losing access to state lands for foraging.
After attempting to get a meeting with the DNR on my own, I requested help from the governor's office, and we did meet with the DNR in August of 2023. During this meeting, the possibility of new quantity limits was raised, and the DNR said that they were considering a 1-gallon bag limit. I asked the DNR staff where that particular limit came from, and we really didn't get much of an answer other than they were just trying to come up with something reasonable. And when I told the DNR why that limit was worrisome, or why it was troubling for us, was because that many of the mushrooms that people forage just simply do not fit into a 1-gallon bag. And the response that I received was, "Really?" And we said yes, which is why we would like to be at the table when you are potentially considering rules that would really severely restrict it. That response was the reason why foraging experts are wanted to come to the table. Most Minnesotans, including myself, do not have access to wide swaths of private land, and state lands are really paid by the people. Taxpayers fund the maintenance and protections of these lands, and I think it's only reasonable that people be able to forage and be allowed to do that with potentially some restrictions. Foraging is such a huge part of my life. I grew up in the Iron Range. Nature is a huge part of my life. I did have my boys up here earlier today. They're 11 and 13, hoping that they were going to be able to participate today, but the committee hearing got moved. Nature and foraging is really making a comeback, and honestly, people need access to state lands to do those things. And having a task force and having the right people at the task force to develop those rules and what the regulations might be seems like a pretty reasonable request, and we'd really appreciate your support. Thank you.
Thank you, Ms. Erickson, and I'm sure your boys, you can show them the YouTube video to your boys.
They're good.
And next up, President Martignacio, I'm sorry. Please state your name for the record and you may begin.
Thank you, Chair, Senator Pa, and committee members. My name is Peter Martignaco, and I'm the current president of the Minnesota Mycological Society. And I thank you for the opportunity to testify in support of Senate Bill 1464, which would establish the Minnesota Sustainable Foraging Task Force to support a science-based approach to foraging policy with a range of voices to support the Minnesota DNR. The Minnesota Mycological Society was founded in 1899, and for 125 years, our mission has been to study and educate the public about fungi, including teaching identification to safely gather mushrooms for food. Equitable opportunities for sourcing nutritious food is being one of the core motivations of our founder, Dr. Mary Whitstone, a pioneer in providing women's and children's health care in Minnesota. The Minnesota Mycological Society, Minnesota Foraging Alliance, and all their partners support this legislation to better manage responsible and sustainable foraging, being recognized as a valuable means of connecting families and children with our natural world. The understanding of foraging in Minnesota has generally come from those that have had long cultural traditions of foraging. Our indigenous communities easily come to mind, but also many immigrant communities have long traditions of foraging that they seek to share in their new home. For example, immigrants from the Hmong, Karen, Vietnamese, East and West African communities, as well as many citizens from Eastern Europe, all come from long, passionate cultural foraging traditions. Foraging is much more part of Minnesota's lives than we may realize. In a survey, 1 in 3 had done foraging activities in the previous 12 months. Thousands of Minnesotans harvest wild rice. Many of us had our first introduction to foraging while picking berries, and thousands travel to pick blueberries every year. While not generally pursued on public lands, maple syruping is another foraging activity that has many enthusiasts. For over 2 years, the DNR has been very clear in refusing to include foraging stakeholders or their elected representatives in discussions regarding foraging policy, and we have real concerns that access to public lands are going to be restricted, not based on any science,
but that foraging is somehow not compatible with the protection of state resources. As the Director of Parks and Trails has communicated verbally and in writing that foraging is not compatible with protecting state park resources, this despite 35 years of sustainable foraging harvest under current regulations. Promoting outdoor engagement, the DNR has expends considerable resources toward outdoor activities like off-highway vehicle recreation, mountain biking trails development, as well as many other initiatives to get out more. Promoting outdoor engagement and improving access, DNR accommodations, direct promotion of many outdoor pursuits points to a missed opportunity, as foraging is an immersive activity that directly connects us to the land. It provides for an outdoor pursuit that is accessible without great expense and will provide equitable access to some of the most nutrient-dense food available to our citizens. We advocate this legislation because if foraging is to be acknowledged and supported as an outdoor activity, it must have regulations that reflect its own unique requirements for management. This does not mean less regulation. It means regulations that are acknowledging and addressing concerns both in policy for publicly sharing resources and conserving those resources. We seek to develop thoughtful recommendations for policy and regulation to guide the management of this outdoor pursuit as a responsible and sustainable activity. While not widespread today in the United States, foraging for personal use has been done sustainably for hundreds of years in all parts of the world.
Sir, could you please wrap up your thoughts?
Yep,
And then
thank you. I want to encourage the committee to support this legislation as we can continue to show national leadership in recognizing the value of foraging as a part of our connection to the outdoors.
Thank you, sir, for your testimony. Members, any questions or comments? Senator Drazkowski.
Thank you, Mr. Chair. Thank you, Senator Pop, for the bill and for your efforts around this. My heart is fully with you. We own this state land, and the people of Minnesota should have access to do the things they do. I guess I've never called it foraging before, but I've done all of these things on private land, and you know, this is where it comes to individual responsibility, or do we have big government? And Senator Pa, you've gotten more government built into this, and you missed my Doge amendments from before, and I've got one for your bill. I'm not going to offer it today, but we're building government bigger and bigger and bigger, and they're going to come back, and you're not going to like what they do either. There's not going to be any super intelligent entity that comes up, or there's not going to be any super intelligent design about this commission or task force that is somehow going to yield anything that has some sort of divine reflection on it, if that's what we're thinking is going to happen. And apparently it's contagious in this legislature, and we think that that's the case. Senator Powell, if I were you, I would delete section 1, and then I would strike the last 4 words on 3.13 of the bill and put a period there. So it would say, the Commissioner of Natural Resources shall not commence or complete any rulemaking on foraging, period. And then wait until the legislature decides to have the will to change that before we go any further. And I've talked to the DNR about this. They're willing to talk to you guys about this. To create another task force, I don't think that's necessary. It's building government bigger. Let's tell the department to leave you alone, and then have them sit down with you and move from there. That's what I would recommend. I liked your bill as it was introduced originally, but I don't like it now the way it is. I think we're going in the wrong direction in terms of how we get there. I like the idea of, you guys take the reins and tell the DNR to leave you alone. I'm with you. Thank you, Madam Chair, or Mr.
Thank you, Senator Drazkowski. Senator Pa.
Thank you, Chair Hyung, and thank you, Senator Drazkowski. I'm going to try and say it right. I'm also one that loves foraging. Me and my kids go out every single year, and they get just as excited finding their first mushroom as they do catching their first fish when we go for our fish opener. And we have such a great time. Kids love this activity, families do. But that's what we're talking about, is that our DNR department has been trying to do rulemaking around foraging and restricting and prohibiting foraging. And so unless the legislature takes a stance and say, no, and this is what we recommend for foraging laws here in the state of Minnesota, we really are, Minnesotans are at risk of not being able to forage at all on any of our public lands. And that's what we're talking about. So I understand what you're saying about just saying no rulemaking, period, from the department. But obviously, they're doing it now, trying to do it now, with or without our consent. And so right now, we have to do something about it. And I would love for something to be written. And I agree with you. Maybe it is that we just say no rulemaking, period. But then, what is going to be our rules? What is going to be our rules? If we don't have a task force of experts who are going to advise us, because I'm no expert when it comes to of what is sustainable. And so we're really depending on people who have the science knowledge, the data behind it to say this is what sustainable foraging is, so that we can really make policy decisions that are informed and educational based on the experts' recommendations. I do think the legislators should decide and not leave it to the department to decide for us and for all Minnesotans.
Thank you, Senator Powell. It looks like we have a testifier. Please state your name for the record, and you may begin with your testimony.
Thank you, Mr. Chairman. For the record, Bob Meyer, Assistant Commissioner, Department of Natural Resources, and thank you for allowing some testimony on this, and thank you, Powell, for the bill. We have been working with her on that. I just need to set the record straight on this rulemaking issue. In 2023, we embarked on a set of rules in a larger outdoor recreation rule package that we've been working on regarding state parks that haven't been updated since 1990. A piece of that dealt with foraging within state parks. We have 230,000 acres of state parks out of the over 5 million acres of state land that we manage, 4 million plus acres of state forests, over 1.5 million acres of wildlife management areas that are all open for foraging. Our concern is that the impacts that large groups of foragers were having on state parks, much like we saw during COVID, where the only place people could go outside and recreate safely were our state parks, our outdoor recreation system. Since then, we withdrew that rulemaking, that piece of the foraging. We are not actively working on any foraging rules right now, nor are we contemplating any foraging rules. The Outdoor Rec Act in Minnesota statute clearly defines activities that can be allowed on state lands, our state parks, our wildlife management areas, state forests, scientific natural areas, and other units of the State Rec Act. So we're glad to work on that. I just want to set the record straight. We are not working on any rules. The rulemaking that we began with in 2023, through our current rulemaking, the Chapter 14 rulemaking process, as you may be aware, is we develop a draft rule, then we submit that out for public comment. So that's what we were waiting on, is developing the draft rule before we shared anything out with people. And if we got to that point, we would have had a robust public comment and engagement period as the rulemaking procedures allow for. So we look forward to working with you. I do have a question on the amendment, though, on lines 1.9, where it says the Commissioner of Natural Resources must provide subject matter resources and expertise. I'm not sure what those resources are. So as we develop the new fiscal note on this bill, I would just like to have some clarification on what DNR resources would be.
Maybe Senator Powell or one of your testifiers could enlighten us on this. Senator Powell.
Thank you, Chair. So the LCC recommended that we add this piece as an amendment to our bill, because as in previous task force, when the LCC has helped support a task force, it was good to have subject matter experts, and that would be also our DNR department, to also help support the work. And so that's why we put this in there, but it was a recommendations from our LCC. That includes all the other members as well. Currently, right now, the DNR already has on our bill 3 members on there. So this would be anything that's additional from those 3.
All right, thank you. Assistant Commissioners, does that answer your question?
Mr. Chair, thank you. No, I understand the staff piece of it, but am I supposed to bring, I don't know what the resources piece means, right? So we can continue working on that as we move forward. And because there are substantial resources that are required for this bill to move forward. The DNR portion of the fiscal note has been completed. I'm not sure what the LCC costs are looking at, but as we move into budget development and knowing that resources are extremely scarce, I would like to be able to do this as cheap as possible. And now the per diem and things just added the cost to it. But we'll deal with that as we work on the finance targets and committees.
Senator Drazkowski.
Thank you, Mr. Chair. Well, Mr. Chair, Mr. Meyer, Senator Pa, my idea costs nothing. And Mr. Meyer, does the DNR like my idea? It would say, the Commissioner of Natural Resources shall not commence or complete any rulemaking on foraging, period. Is the DNR opposed to that? It sounds congruent with what you're planning.
Assistant Commissioner.
Mr. Chairman, any prohibition on rulemaking may impact other things into the future, so we would not support that at this point in time.
Well,
Sir,
Mr. Chair,
Drazkowski.
Mr. Meyer, it would just be on foraging, period.
Assistant Commissioner.
No.
All right, Senator Drazkowski, are you looking to make a motion on your oral amendment there?
No, I'm not, Mr. Chair,
right.
but thank you. Senator Pa, I'm going to encourage you all the way on offline. Thank you, Mr. Chair.
Senator Drazkowski, I appreciate your creativeness. Seeing no further discussion, Senate File 1464 as amended be recommended to pass and re-refer. Seeing no further discussion, Senator Gustafson moves that Senate File 1464 as amended be recommended to pass and re-referred to the Rules Committee. All in favor say aye. Aye. All opposed say no. The motion prevails. Senate File 1464 as amended is recommended to pass and re-referred to the Rules Committee. Thank you, Senator Pa. Next up, our final bill. Senator Rarick, we saved the best for last. Senate File 2819. Whenever you're ready, you may begin.
Thank you, Mr. Chair. I was going to say this is the bill you've all been looking for tonight, not because of the author or the subject, but just because it's your final one. Mr. Chair, members, Senate File 2819 is a bill that we're looking at putting some basic parameters around a new, I shouldn't say new, but a re-emerging way of looking at burying human bodies. And it is, what was discovered is because so many cemeteries are run by churches or by, say, city or other municipalities, there were not any provisions that were in place for protections as we bury human bodies. And so in 23, we did a moratorium on any new cemeteries that would do these natural burials. And MDH did a bit of a study looking at some green burial parameters that have been studied by these organizations and what other states are doing. And that is where we have come to with this bill, some very basic parameters that our county officials in particular have been looking for. This gives them some comfort to be able to see some minimum burial depth requirements, some setbacks, some distances from water that they can take and use for local zoning purposes, and then to use the MDH study, look at what the state has and see if they would have any further requirements or guidelines that they would put in place. I believe the description of the bill that you have in front of you, Mr. Chair, is from the original drafting of the bill. In Commerce, we did take an amendment that addressed the concerns that came from the funeral directors and from the Cemetery Association. We had some provisions on how to handle the dead bodies. That's already in statute. We did remove that. And there were some other concerns that we addressed. And my discussions with them since that point is that they are good with the bill. I did also reach out to Senator Fateh, and he connected me with some Muslim groups, and then Senator Wiklund helped me connect with some Jewish groups. Both of them are in agreement that this does not infringe upon any of their traditions that they would do. And so one thing, we do have one amendment today. Former Senator Lane approached us in the other committee and brought up, we have a provision in the bill for the scattering of remains. And there are two processes for which cremation can be done. One is a fire means and one is a water means, and they are defined separately in statute. And so the amendment that I would have for the committee today, I don't have my cheaters, I can't read the amendment number, but
The A4.
the A4, thank you. The A4 would look to change so that we're incorporating both types of cremation as being allowed to be scattered within a certain area of the cemetery and not just the fire type of cremation. So I would appreciate it if a member would move that A4 amendment so we can
Certainly.
incorporate that into the bill.
Senator Carlson moves the A4 amendment. All those in favor of the A4 amendment, say aye. Aye. All opposed, say no. The A4 amendment is adopted. Senator Rarick, any additional comments?
Yeah, just unfortunately, I had a past county commissioner from Carlton County and a current commissioner unable to stick around to provide testimony today. But what they were basically going to testify to is that they were looking forward to some of these basic provisions to be put in place, as well as some of the landowners who are adjacent to a property that is being looked at for this in Carlton County, so that these basic parameters in place will give them much more comfort to be able to have this move forward within the county. And like I said, the county commissioners especially, this allows them to have some information in place that they can refer to that helps allow them, if they want to look at any zoning or anything else within the county, that they now have a basis to operate off of and they're not kind of operating blind. And as a small county, they didn't have the wherewithal to come up with a lot of this. So with that, I do believe there is a testifier who I would.
Certainly. Mr. Connell is here with us. Thank you, Mr. Connell. You stayed with us throughout the entire committee, as if you're an honorary member of our state and local government committee. Whenever you're ready, please state your name for the record, and you may begin.
Yes, sir. Thank you, Mr. Chair, and thank you, members. My name is Matt Connell. I'm the caretaker at Loving Earth Memorial Gardens in Carlton County. I spoke before the Commerce Committee the other day, and I wanted to make sure everyone understands that while I feel strongly that the moratorium in this bill were unnecessary, I'm not necessarily opposed to regulations on natural burial. I'm glad we can move forward now with confidence, knowing that natural burial is very safe, as it has been forever. I just wish that I hadn't been the sole target of a 2-year moratorium for us to get here. So for me, it's not the what's so much, but the hows and the whys I find troubling. Mostly the whys. So I ask this question with all due respect to everyone here. Is this concern regarding green burial an environmental issue, an issue of a website's tips and suggestions page, or is it deep down at its core a cultural issue? It's simple. Things that seem different from what we're used to can feel disruptive and make people feel uncomfortable. And death is seen as taboo and is hard to talk about. But what we're doing in Carlton County is meant to uplift the entire community. We've taken a 20-acre hayfield, planted hundreds of trees and a huge amount of wildflowers this past year in order to create a sanctuary for pollinators, for wildlife, and for anyone who chooses to truly return to the earth when they die. We're also creating a sanctuary for those who are grieving for any reason, with nature trails, meditation spaces, and a chapel open to everyone. It's true that it's not at all what people picture when they think of cemeteries. But either way, the land we purchased was zoned as Ag 2, where in Carlson County, cemeteries were permitted use with no conditional permit required. When something is permitted use in a county's ordinances, it implies community approval. A county has always had the ability to allow or not allow cemeteries wherever they choose. It's also implied that a green cemetery would be viewed no differently than a conventional one, especially now after the state's study. In fact, there are currently 7 cemeteries that are already providing natural burials across Minnesota. This is partly why we feel unjustly treated and discriminated against by the county. The county wrote a complaint letter to the Green Burial Council about us pertaining to their perceived lack of community support. But perhaps they should have just written it to themselves, since they were the ones with the power all along. The letter is, in my eyes, disingenuous and misleading. Before I go, it should be known that we have a great respect for the work the Green Burial Council has done for the movement. But please keep in mind that the GBC is not a government and/or enforcement entity. It's perfectly reasonable to disagree slightly with their tips and guidelines while still being green. This movement is constantly evolving, as it should be. In fact, there's now another organization, the Global Green Burial Alliance, where debate and discussions happen all the time, and we've received a lot of support. But I digress. The bottom line is that we are good people who want to provide something beautiful and beneficial for Carlson County and all of mankind. We don't have ill intent at all. We care a lot and feel strongly that soon those who have or have had concerns will see their fears were unfounded, and one day we'll all be friends, we'll come together and support one another as neighbors to be loved and not enemies to be destroyed. Thank you so much for your time.
Thank you, Mr. Connell. Members, any questions or comments on the bill? Seeing none, Senator McQuaid.
Thank you, Mr. Chair. I'm just wondering what the path is for this bill?
This is going to HHS.
Okay.
Senator McQuaid.
Thank you, Mr. Chair. Thank you, Senator Rarick. I really like your bill, and I think the one question I had, I actually think is more appropriate in HHS, so I won't ask it here. But thank you for bringing it and for doing the work.
Thank you, Senator McQuaid. Senator Rarick, any final comments?
No, Mr. Chair, I just appreciate the time here, and like I said, I wish this the study would have come out in October, so I could have worked closer with folks and not had this be such a last minute, but I really appreciate you and your CA working with me to get this on your schedule, being we did not get the bill jackets until just last Thursday, so I really appreciate that, and thank you.
All right, thank you, Senator Rarick. Senator Drazkowski moves Senate File 2819 as amended to be recommended to pass and re-referred to the Health and Human Services Committee. All those in favor say aye. Aye. All opposed say no. The motion passes. Thank you, Senator Rarick.
Thank you.
And with that, members, we are adjourned. Thank you.